Hey, everybody. Welcome to another edition of Talks on Immigration. Today, we are going to be discussing adjustment of status and legal permanent residency. This is an exciting topic, so please don't go anywhere. Hey, everybody, and welcome to another edition of Talks on Immigration. I am attorney Carlos Wetton. I am the managing attorney of the Seattle office of the law firm of Jaime Barron, and we exclusively practice U.S. immigration law. Today, I am joined by a very special guest and one of my great friends, the managing attorney of the Fort Worth office, Marissa Daniels.
Hi, everybody. So
Good
glad
morning,
to be on
Marissa.
the show and joining my good friend Carlos.
Marissa, how are things in Fort Worth this morning?
Just another day in paradise. Can't complain. How are things in Seattle?
Well, surprise, surprise, I woke up to some clouds and I woke up to some rain.
We are bright and sunny and unseasonably warm today. I think we're expecting 80 degrees today.
Oh my gosh. Yeah, I do miss the Texas sun. I won't lie. But, getting a little bit of rain on my face isn't too bad. I've learned to kind of adjust to it over the last 6 months.
Sure.
Well, Marissa, thanks for joining us today. You and I have been discussing a little bit about adjustment of status and what's called an application for legal permanent residency. So, maybe you can start us off by kind of explaining a little bit what adjustment of status is.
Sure. Essentially, speaking generally, right? It is the application or the process that is submitted in order to request your residency. So there are different bases for an adjustment of status. It can be asylum based. It can be a family based adjustment of status. It can be VAWA, U visa. There are various types or bases for an adjustment of status. Depending on the type, will determine the requirements, the eligibility. So adjustment of status sort of encompasses a lot of different processes. It just depends on what the basis is.
So you mentioned eligibility. Is this something that anybody can apply for? So for example, if you enter undocumented, you've been here in the United States for a few years and you think, you know what, I want to become a legal permanent resident. Is this something that anybody can do, or who exactly is eligible for adjustment of status?
So in general, not everybody is eligible for it. That would be, a dream. However, just your time in the United States and, great moral character, no criminal history is not enough. Unfortunately, the way that it works is, and I guess we can maybe focus today on spousal or family based, where it's a marriage based adjustment of status, just to sort of focus in on one of the topics, right? Or one of the bases. For this type of adjustment of status that's marriage based, in general, the applicant will have to have a lawful entry, and that would be whether they were inspected and admitted or inspected and paroled into the United States. And they would also generally have a United States citizen spouse. Now, there are rare exceptions where a resident spouse might be able to petition for an applicant and actually get an adjustment of status filed. However, those are rare. They're unique. In general, for a marriage-based adjustment of status, we're talking about a lawful entry and marriage to a United States citizen.
So you mentioned the requirement that someone be a United States citizen for an adjustment of status in most cases. You also mentioned a petition from the spouse, if I'm correct, right? So talk us through what that petition is exactly.
So a spouse petition is essentially the spouse is establishing the relationship. They're saying, I am a United States citizen. They're proving their lawful status and their relationship to the beneficiary. So I'm married. I'm a United States citizen married to the beneficiary, and my beneficiary has a lawful entry. Now, the lawful entry comes in at the adjustment status, but the petition is essentially just establishing the relationship between the petitioner and the beneficiary. The petition in and of itself doesn't grant a benefit. However, the additional parts that come with an adjustment of status are what will grant that benefit, the residency. So the petition itself is establishing the relationship, a United States citizen spouse married to a beneficiary.
Thank you, Marissa. I think it's important that you mentioned that a petition in and of itself doesn't necessarily grant any particular benefits. I don't know about you, but I get questions all the time from someone that asks, okay, if my spouse files this petition for me, am I eligible to work? Am I eligible to leave the United States? And it's important to remember that the petition itself is just the United States citizen spouse basically asking the government, hey, this is my spouse. I want an immigrant visa for them.
Right. Yes, that is a common misconception. We try to make it very clear. A petition is essentially establishing a relationship where we're going to prove, hey, this is a valid, good faith, bona fide relationship, and this is my actual lawful status. And because of my lawful status and this relationship, I am allowed to petition, which is step one, my beneficiary or my spouse. So no actual benefit, but it is the preliminary step for the benefit of residency.
And it's necessary as well. So to apply for residency, you need those two processes. You need the petition, and simultaneously you need the form that you submit to apply for residency. So let's talk about that, Marissa. The process. Let's say that somebody's married to a United States citizen, and the United States citizen tells their spouse, hey, I want a petition for you. I want you to become a legal permanent resident here in the United States. And so they come to us and we tell them, okay, this is what the process is. So let's discuss that a little bit. What kind of forms are submitted to the government in order to complete this adjustment of status process?
Sure. So in general, an adjustment of status application or packet will be submitted to USCIS, which is the United States Citizenship and Immigration Services. That packet generally includes the petition, which is the petition by the United States citizen spouse establishing the relationship. It will also include the application requesting the residency. In general, it's also going to include a work permit application where we're soliciting work authorization for the applicant. And sometimes it can include a travel permit application, depending on whether the applicant is interested in maybe traveling while their adjustment is pending. There are some risks with that, but there are many people who are adamant, and it's not necessarily something that is bad, but we always warn anybody, anytime you leave the United States, there's always a risk, right? So, of course, we can request it, and we do without issue. However, there's always an evaluation analysis that needs to be done each time someone plans to leave the United States while a process is pending.
Exactly right. I warn my clients the same thing. I say there's always a risk if you travel outside of the United States without legal permanent residency or without being a United States citizen. But this is a benefit that's available to people who have a pending residency application. And so that's definitely something that we like to offer all of our clients, this opportunity to travel outside of the United States while the application is pending if they feel that there's a need to. So in addition to the forms, there's also a kind of another important form that we have to make sure is either included once the application is sent or given to USCIS at a later date. Could you explain, Marissa, what that very important form is?
Sure. So with every application, there is a medical exam that must be submitted along with the application, if not at a further time once United States Immigration Services asks for that. General practice or best practice at this time, based on processing times, is to include the medical exam with an adjustment application. We know the medical exam is valid for 2 years. Right now, based on current processing times, our hope is that you're getting a decision well before the 2 years. So including that might be a benefit. Today, this could all change, right? But based on current processing times, including the medical exam might be a benefit to avoid delays in your case. The medical exam essentially consists of confirming you've received all of the required vaccinations, making sure there are no health inadmissibility grounds that might apply in your situation. So with every application or with every case, they must receive a medical exam. Additionally, if we're going to go ahead and talk about some of the other things that we should include, right? So the forms are part of it. The medical exam is part of it. There are always government fees that accompany almost every application that you submit to the government. So those government fees have to be submitted along with the packet. Right now, actually, just recently, we've gotten the confirmation that government fees will increase effective April 1st. So if you are eligible, if you think you're eligible, right now is the time to get moving on this to avoid those extra fees that will indefinitely be in effect April 1st.
Yes, I'm glad you mentioned that, Marissa. As we know, the fees are going to be going up for pretty much every process that we're going to submit to USCIS. USCIS is funded by the government fees, and so they reserve the right to increase the fees when they feel like they need to. Now, also something important to remember is that starting April 1st, a work permit, a travel application, it's not going to automatically be included in the overarching fee to apply for residency as it is right now. So in the future, after April 1st, if you want to apply for adjustment of status or your spouse does, and if they also want a work permit or if they also want a travel permit, that's going to up the fees that you will need to pay to USCIS. And Marissa, in fact, we actually have a question that has come through from Brian, and I'm going to go ahead and read this. Does projection letters from work can help in your affidavit support if you didn't make enough money last year in your tax return? That's a really interesting question. Brian brings up an interesting point, is that the petitioner itself needs to show that they make enough money in order to support the immigrant or their spouse that they're trying to make a legal permanent resident. So they have to reach a certain economic threshold in order to prove to the government that their spouse is not going to become a burden, meaning that they're not going to, be using government services immediately after they become a legal permanent resident. So let me ask you, Marissa, if you could answer this question for Brian. Would a projection letter from work be enough in an affidavit support if he hasn't made enough money in his last tax return?
I'm going to say, based on current trends, possibly not. However, worth including. Worst thing that will happen is that on that case, you'll receive a request for evidence. And at that time, hopefully you'll have a little bit more check stubs, more pay stubs, more to establish that you do currently qualify based on your current income. So worth including in your packet if you don't currently qualify, but keep in mind, they could still say, yeah, projected income is not current income. So they do have to base it on what your current income is. So again, include it. If you're worried and you want to avoid delays, there's always the option of adding a joint sponsor to an application. That's an option. Might save you a request for evidence, might save you time, might help that case be adjudicated quicker. So it's a balance, and it's something an option we always give our clients when we're in this situation, which is pretty often, to be honest with you. So something to think about, include it, possibly request for evidence, delays in your case, or maybe think about adding a joint sponsor and hopefully avoid any delays.
Of course, that's what I always recommend as well, that when in doubt, if you have some questions about, maybe you have non-traditional sources of income, you own your own business, maybe it's hard to establish that you make that kind of money. First off, talk to an attorney, give us a call, schedule a consultation with myself, with Marissa, and we can go over all that information with you and decide if maybe having a joint sponsor really is your best option in order to avoid a request for evidence and get your case hopefully processed as soon as possible. So Marissa, let's talk about evidence, which we've talked about the forms, we've talked about the medical exam, but when you're establishing a marriage, when you're establishing the proof necessary for an adjustment of status, the government actually requires evidence to show that this relationship is real. So could you talk us through the evidence that's needed?
Sure. Some of the basic evidence that the government is going to require is going to be birth certificates of both parties. If the petitioner is not born in the United States but naturalized, of course, the naturalization certificate should be included. Marriage certificates, marriage licenses should be included. If they were previously married, of course, we want divorce decrees finalized showing that the current marriage is valid. Any kind of joint accounts, joint endeavors where both names are on accounts, whether it be bank accounts, saving accounts, even life insurance, bills, mortgage, rental agreements, all of that is going to lend to this is a bona fide marriage, a good faith marriage. Of course, if you have children in common, include those birth certificates. That's definitely a very convincing, good faith marriage evidence to include. In addition to that, of course, because like Carlos mentioned earlier, we do have to establish that the petitioner makes a certain amount based on the number of dependents they have. We do have to include evidence to establish what their current income is, what previous year's income was. So that's some of the evidence, and that tends to be more the primary evidence. Of course, there's that secondary evidence, which is your photographs, where we're saying, hey, look at us. Although we've only been married a year, we've been together 10 years, and here are pictures from back when we were just 17 years old and went to prom and so on. So all the pictures that they've had, even letters from family, friends who can attest to this relationship, this marriage being a good faith marriage, a legitimate marriage, all of that can be included in there as well.
Yes, that primary versus secondary evidence is an important distinction because in my experience with attending these interviews and preparing these packets, USCIS really wants to see that your financial lives and your lives are intertwined. So that's why they look at, bank statements and a lease agreement and possibly insurance and information like that. Secondary evidence, the pictures, the affidavits are great. They help establish your relationship and kind of give some context to the adjudicating officer. But if you're just submitting secondary evidence, I think it's going to be harder to get your application approved. So you really got to try and have that primary evidence be strong and sufficient. So the officer looks at all this and says, hey, their lives are together. They are mixed in. And I agree with you. Birth certificates of children born to both, it's fantastic. That's the best evidence I can include. And if somebody brings their baby to the interview, it's kind of an undeniable fact.
There you go.
Good faith marriage. Okay, so what are we looking at, Marissa, as far as interviews go? Now, we've kind of mentioned and peppered in interviews a little bit into the conversation, but if you can give me an example of what can somebody expect at an interview, is an interview always required? And how long are we seeing that these cases are taking right now?
Sure. So processing times vary per jurisdiction, per field office. So I recently looked at both Seattle and Dallas, and it looks like we are neck and neck. So I would say across the board, we're looking at about 15 to 18 months for an adjustment of status case. So what that means, that does not mean that you personally are going to get a decision within the 18 months. It means that on average, 80% of all adjustments that are submitted are a decision is issued within that time frame. Of course, there are those few that are going to fall outside, but there are things that we can do. Make sure you're staying in touch with your attorney or reach out to an attorney if your case is stuck or beyond or outside the processing time. So I would say anticipating an interview around 15 to 18 months is average. Keep in mind when we say anticipate an interview, in general, you should anticipate an interview based on a marriage. However, current trends dictate differently, have sort of led us to believe that on marriage ones where there's sufficient evidence to establish that this is a good faith marriage, oftentimes they are not even scheduled for an interview. However, normal practice is expect an interview, prepare for an interview, submit everything as complete as possible, as thorough as possible, anticipating an interview. And also, in case you don't get an interview, you submitted it all correctly, all completely. There's not going to be an issue in the future since they didn't issue you an interview. Now, with the interview, your expectation should be meet with your attorney, meet with your team, get prepared. We here personally meet with all clients before they attend their interview. We prepare them, provide them a list of all docs that they should be taking. Everything that was originally submitted with the package, the originals should be taken along with a copy, because the officer can keep your original if you only take the originals. So we'll advise them to take a copy of everything previously submitted with the packet along with their originals. We also advise them to take good faith marriage evidence from the time that the case was filed until the interview. That way we can show that if there's any doubt in their mind, or if they still haven't confirmed or made a decision that a good faith marriage actually exists, you know what, here's the last year and 2 months worth of evidence that this is a legitimate marriage. We've now purchased a home. We're now expecting a baby. All that additional evidence of good faith marriage should go in to the packet you're going to take to your interview. The interview is usually you, your attorney, translator, and the officer. They'll generally review your application, review any documents, and again, they might ask to see the updated bona fides, and potentially if more time has passed and a new tax year has come in, we advise you to go ahead and bring in those new documents establishing that you continue to qualify to sponsor your family member. One, because remember their determination is based on current income. So we want to make sure we're establishing you still qualify as a sponsor.
It's an opportunity, in my opinion, Marissa, that if maybe the evidence wasn't so strong at the beginning, maybe they had just gotten married and they submit what they have, but it's not that strong, then waiting for the interview is an opportunity to start gathering more evidence, adding your spouse on your lease agreement, opening a bank account together that you use. So in preparation for the interview, and I'm not sure about you, Marissa, but I've been hired on a couple of cases to go to an interview for an application that was already submitted by someone else, not by us. And I've been able to see kind of what a lack of preparation and a lack of evidence does to the interview. It makes the interview a lot more difficult because the officer is asking kind of more in-depth questions. Maybe they even separate the couple, so, just to see. So it really pays off to submit good evidence, as much evidence as possible at the very beginning of your application, so that possibly maybe you can avoid an interview, but especially so that you can be best prepared for an interview when it comes.
No, absolutely. Absolutely. And that is why every adjustment of status case that we hire here is given a very detailed, long list of potential evidence that may exist in those cases. And even if every single one of those documents or evidence doesn't exist, that is okay. It is just sometimes giving them ideas of, oh, I haven't even added them as a beneficiary to my life insurance, but I do have it. And I've had many situations where they're like, you know what? We've been married for 6 months and I totally forgot to update that. And I'm like, okay, we'll do it now. Let's go ahead and get it included in with your packet, stuff like that. So yes, it really is important to submit a packet as complete and thorough as possible.
So Marissa, it's about time for us to wrap up a little bit. I just want to talk briefly on what happens after. Let's say you go to the interview, you submit everything, and the officer goes, I'm going to recommend your application for approval. What comes next?
Sure. So, congratulations. You have been approved for your residency through a United States citizen spouse. So, one of two things. If this is a newer marriage, if this decision is being made and you do not have 2 years of marriage at that time, then you will receive what's called a conditional residency. Don't get discouraged. You still have the same rights, the same privileges as those with a 10-year residency. The only thing is immigration is going to make you come back, remove those conditions, and establish that this truly is a bona fide marriage. So if you get a conditional residency, you'll have an additional step to remove your conditions. But again, you get to work, you get to travel no differently than your residents who get the actual 10-year card. If you get a 10-year card, then you don't have to renew your residency for 10 years. You don't have any removal of conditions. The good thing about your cases, whether it's conditional or a 10-year card, you will be eligible for your naturalization under an exception. It's called a 3-year exception because you actually obtained your residency through a United States citizen spouse. Now, this exception, because in general, you must wait 5 years. You must have 5 years as a resident to apply for naturalization. This exception for those who obtain their residency through United States citizen spouses exists only if you remain married and still living together in good faith, and you get to file within at the 3-year mark instead of the 5-year mark. You will have to do it in English. You do have to establish you're still married in good faith and living together. So it's sort of including some of the evidence, just like we did at the adjustment stage, that you're still married. And if you got your conditional, you will file your removal of conditions. You're still eligible at your 3-year mark. So even though your removal of conditions is pending, we can still file your naturalization. And chances are, at least based on what we're seeing here, we're going to get your naturalization interview before they even make a decision on your removal of conditions. However, that's okay. Not a big deal. We bring your spouse to your naturalization interview and you're granted your citizenship, and your removal of conditions is void. There's no need for it anymore, right? So that's the good thing about your obtaining your residency through a United States citizen spouse. You get that, you fall under that 3-year exception.
That's fantastic. It really is a huge benefit that I'm not sure a lot of people know about, that ability to apply for naturalization under that 3-year exception. Well, Marissa, sadly, our time is up, but please come back and visit us again for another talk on immigration. What do you think?
Yes, absolutely. Thank you all for having me. This was a pleasure. Anytime, Carlos.
So let me remind everybody that we have offices across the country in the Dallas and Fort Worth area, in the Washington, D.C. area, and in Seattle. If you'd like to schedule a consultation with me in Seattle, please give us a call at 206-274-1400. Also, you can call us at any time to schedule a consultation with Marissa if you're in the Fort Worth area. So please schedule a consultation, give us a call. We'll answer your questions. We'll resolve your doubts. And we will see you next time for another edition of Talks on Immigration.
Thank you, guys. Y'all have